Hey, dear audience, are you scared? Know your rights. Your tenant rights in cases of unfair eviction in California. Tenants in California have the right to sue their landlord in civil or small claims court if they are unlawfully evicted. If a tenant sues for eviction, they can claim that the eviction was unlawful as a defense or counterclaim. In the event of a tenant's eviction, they may be able to sue for damages such as fees for the court, legal expenses, damages for wrongdoing, decrease in the rent-controlled unit's worth, transportation expenses and mandatory relocation levies, feeling down and out. For damages and the right to reoccupy the unit, tenants might file a lawsuit. A court can provide the renter compensation if it can be shown that the landlord behaved with malice. The time restriction for filing a case alleging wrongful eviction in California is 2 years following the eviction. Additional protected behaviors that tenants can engage in include notifying housing authorities of infractions, submitting a request to the rent board. A wrongfully evicted renter has the right to claim for damages and the right to return to the unit. If a tenant exercises their rights as outlined in the rent ordinance or any other applicable law, the landlord cannot respond with retaliation. Reporting infractions of the housing code or submitting a petition to the rent board are examples of protected tenant acts. A tenant who is illegally evicted may sue to reoccupy the unit and for damages. A landlord cannot retaliate against a tenant for exercising their rights under the rent ordinance or other laws. Protected tenant actions include reporting housing code violations or filing a petition with the rent board. Call now 714-442-9741. For further insights, call Martinez Law Center, specializing in California tenant-landlord laws.